This will be the second in my series on the top 7 myths about bankruptcy. Myth number 2, I'll lose my house and my car. When a potential client calls me, one of the very common questions I get is, well, I'm going to lose my car if I file a bankruptcy, aren't I? Or I'm going to lose my house if I file a bankruptcy, aren't I? And the fact is that is almost never true. I did talk to somebody a while ago who had some kind of a super cab extended pickup truck that was paid for and had almost no miles on it, and the blue book value was $30,000, and that could be a problem, but that sort of a thing is an exception to the general rule. As a general rule, my clients are either upside down in their cars or they only have a couple $1,000s of equity in their cars. And usually claiming that as exempt is not a problem. Now, when you file a bankruptcy, it is true that the personal debt will be discharged unless you reaffirm the debt. I talk about what a reaffirmation is elsewhere. Unless you reaffirm the debt, the personal obligation will be discharged, but the lien on the car or the lien of the mortgage on the house will remain. So it's kind of as if the car still owes the loan or the house still owes the loan, even if you don't owe it personally. So the main thing about keeping a house or keeping a car is you have to keep up the payments. In a Chapter 7 bankruptcy, which is the most common kind, as soon as the case is filed, a trustee is appointed by the court. The trustee's job is to try to find assets for the creditors. My job is to try to make sure that either the trustee doesn't find any assets or finds very few assets. And the way to keep a trustee from getting their hands on an asset is to claim it as exempt. The exemption for a homestead under the state exemptions, those are the best ones for a homestead, is $480,000 of equity. So I guess maybe once or twice I have run into somebody who's got a multi-million-dollar house down in Lake Minnetonka, and they've got more than $400,000 of equity in the place, but that's very rare. The general rule is that if you're a Minnesota resident and you're going to file a bankruptcy, keeping the house isn't that much of a problem. You claim it as exempt under the state exemptions. We also have a list of federal exemptions that you can use, but those aren't very good for exempting houses. They are pretty good for exempting automobiles. The state exemption for a car is $5,200. The federal exemption for a car is $4,450. Under the federal exemptions, you have a $4,450 exemption for a car. But even if you have more equity than that, we have what we call the wild card exemption. It's kind of a catch-all exemption where you can put anything that isn't exempt under any other provision, and that's $15,000. So in a federal exemption case, for example, if you had $10,000 of equity in your car, we would first use the 4450 exemption that's provided for cars, and that, of course, then leaves more than $5,000. We can put that additional $5,550 or so of equity in the vehicle into the wild card and still protect the whole vehicle. So in the vast majority of cases, Minnesota residents who file bankruptcy are able to keep their vehicles and they're able to keep their homes. There are some exceptions, but they're pretty rare. And those who are telling you that you're going to lose your house and that you're going to lose your car if you file a bankruptcy, they are perpetuating a very common myth about bankruptcy.